Case number 1, Christopher Tapp. In the summer of 1996, Idaho Falls police collected biological evidence from Angie Dodge's apartment, semen and a pubic hair left by her killer. Laboratory analysis was unambiguous. It excluded Christopher Tapp completely, scientifically, without qualification. Police interrogated him for 7 months anyway. The evidence they needed to close the case correctly existed from the beginning. They chose not to use it. Tapp was 20 years old at the time of Angie Dodge's death. Born on July 11, 1976, he had grown up in Idaho Falls, dropping out of Skyline High School and cycling through odd jobs without landing anywhere stable. He lived paycheck to paycheck, had no serious criminal record, and was known locally as harmless. Aimless, perhaps, but not dangerous. What the police reports would document, though never in these precise terms, was that Tapp was acutely susceptible to authority. He deferred. He complied. He wanted the people interrogating him to be satisfied. In a normal interaction, that disposition is unremarkable. In an interrogation room, it can be dismantled and reassembled into something that looks, on a tape recording, like a confession. That disposition, in this room, would cost him 21 years. Angie Ray Dodge was 18 years old. She had graduated with honors from Idaho Falls High School and was working at a beauty supply company. The youngest of 4 children, living alone in a ground-floor apartment for the first time in her life. She was a loose acquaintance of Tapp's, the kind of connection that forms in a small city where social circles overlap and everyone knows someone who knows someone. The night of June 13th, 1996, her apartment was accessible and her door was close to the street. Her coworkers found her when she didn't show up for work, roughly 6 to 8 hours after she had died. The Angie Dodge Memorial Fund was established in her name. Brian Lee Drips Sr. lived across the street. On the early morning of June 13th, 1996, intoxicated and acting on impulse, he walked across that street, broke into Dodge's ground-floor apartment, sexually assaulted her, and stabbed her 14 times, wounds severe enough to nearly sever her head. It was a crime of opportunity, unplanned and unremarkable in its origin. A man who lived nearby, an unlocked or accessible entrance, a young woman alone. Drips left biological evidence at the scene. He left no fingerprints. He walked back home. Tapp, whatever his connection to Dodge, through overlapping social circles, was not present. The DNA excluded him from the first test. Over the next 7 months, Bonneville County detectives administered 7 polygraph examinations to Christopher Tapp across 23 separate sessions. Each time, examiners told him he had failed. Each time, they told him the machine was demonstrating that his subconscious was concealing his own guilt, that somewhere inside him he carried memories of the murder he could not consciously reach. This was a documented lie on every occasion. Tapp had no subconscious memory to surface because he had not been in that apartment. The DNA collected from the crime scene excluded him entirely. Police knew this. They proceeded regardless, session after session, exploiting his compliance and his learned deference to authority figures until the process produced something they could take to a prosecutor. Tapp was arrested on January 11th, 1997, at the Idaho Falls Police Department. Initially charged as an accessory, those charges were upgraded to first-degree murder and rape by Bonneville County prosecutors. Trial began in May 1998 before Judge James Herndon. The prosecution's theory required Tapp to have held Angie Dodge down for an unidentified accomplice, a construction designed to explain why the DNA at the scene was not his. The defense argued the confession had been psychologically extracted through months of manufactured pressure and pointed directly to the biological evidence that excluded their client. Tapp did not take the stand. The jury deliberated for 13 hours and convicted him on all counts on May 28, 1998. In December 1998, Tapp was sentenced to life in prison with a 30-year minimum on the murder charge, plus a concurrent 20 years for rape. At the sentencing hearing, Carol Dodge, Angie's mother, called him a beast. Early appeals went nowhere. The Idaho Innocence Project eventually took the case, and in the years that followed, something occurred that had no precedent in the case's history. Carol Dodge re-examined the confession tapes, listened to what she had not been willing to hear before, and concluded that what she had once taken as proof of guilt was the product of 7 months of sustained psychological engineering. The woman who had called Tapp a beast became his most vocal public advocate. In 2017, Tapp accepted an Alford plea and was released for time served. He was 40 years old. 2 years later, in 2019, investigative genetic genealogy, a forensic technique that uses consumer DNA databases to trace biological relatives and identify unknown contributors, identified Brian Lee Dripps Sr. as the man who had killed Angie Dodge. Confronted with the match, Dripps confessed. Tapp received a full exoneration. He was the first person in the world exonerated through investigative genetic genealogy, and the case became a landmark example of what the technique could accomplish. Before his release, he had also successfully lobbied for Idaho's first wrongful conviction compensation law. The city of Idaho Falls paid him a settlement of $11.7 million. Christopher Tapp died on November 5, 2023, at age 47, in a Las Vegas hotel room. The cause was blunt force trauma. His death is currently being prosecuted as a homicide. He had spent 21 years in prison for a crime the DNA always said he did not commit. The law he helped pass was signed after he left prison. The exoneration came 3 years before he died. The machine that claimed, 7 times over 23 interrogation sessions, to have located his guilt was lying every single time. Case number 2. Daryl Parker. John E. Reid did not invent the polygraph, but he perfected the interrogation technique built around it, a structured, psychologically coercive method of questioning that would bear his name, be adopted by police departments across the country, and become the foundation of American interrogation training for decades. Officers were trained in it. Courts treated its results with deference. Textbooks described it as a breakthrough. In December 1955, Reid traveled to Lincoln, Nebraska, to personally administer his technique to a young forestry worker whose wife had been murdered in their home. The man was innocent. Reid's examination produced a confession anyway. The Reid technique had its first confirmed false confession casualty before it had been widely published, and no one would know it for more than half a century. Daryl Parker was 24 years old, a University of Nebraska graduate with a forestry degree, employed in a profession he had studied for and building a stable life in Lincoln alongside his wife. He had married Nancy, and the two were at the beginning of what appeared to be an ordinary and settled future. He carried no criminal record, no history of violence, no mental health complications, no financial pressures, no motive visible to anyone looking at his life from the outside. By every measure available, he was a respectable young man with no reason to harm anyone. The day his wife was murdered, he was at work. Nancy Parker was 22, a college graduate working as a secretary for a city planner, a young woman at the beginning of her adult life, well-liked by those who knew her, and building a life alongside Daryl in Lincoln. On December 14th, 1955, she was home alone when Wesley Peary broke in on a random, predatory impulse. Peary sexually assaulted her and strangled her to death. He left little physical evidence and departed. He was not a suspect at the time, not a person of interest, not on anyone's list. He would eventually confess what he had done, but only to his attorney, in a privileged disclosure made shortly before he died, in a confidence that would remain buried for decades while Daryl Parker's life was consumed by the consequences. Parker arrived home from work, found Nancy's body, and called the police immediately. Within days, the investigation had fixed entirely on him. The domestic logic was simple and wrong. Husbands were primary suspects in their wives' deaths, and Parker had no alibi that investigators accepted as sufficient. Police brought in John E. Reid, already a figure of authority in law enforcement circles, for his work developing structured interrogation, who arrived in Nebraska with his polygraph equipment. He administered an examination, then told Parker he had failed it. The session that followed lasted 9 hours. Reid applied the full weight of his psychological technique, presenting the result as scientific certainty, constructing face-saving narratives about repressed rage, working the subject's exhaustion and grief against his resistance. Parker was not cognitively impaired. He was not a teenager. He was an educated adult man with every reason to maintain his innocence. The technique broke him regardless. At the end of 9 hours, he signed a confession. He had not read it before signing. The trial, held in 1956 in Lancaster County, rested almost entirely on 2 pillars: John Reid's expert testimony vouching for the scientific validity of the polygraph result, and the confession that result had produced. The defense raised Parker's alibi. He had been at work when Nancy was killed, and the complete absence of any physical evidence linking him to the crime. The jury weighed a credentialed professional presenting himself as infallible against a defendant maintaining his innocence and sided with the expert. Parker was convicted of first-degree murder. The judge sentenced him to life in prison, citing the brutal nature of the crime and the persuasiveness of Reid's account. Parker served 15 years before his sentence was commuted in 1970. He was released and lived quietly, but the case carried no formal resolution. Decades later, a prosecutor reviewing archived files came across documentation establishing that Wesley Peary had confessed his guilt to his attorney before dying. A disclosure that had never been brought forward, never shared with the defense, never disclosed to any court. The evidence was clear and unambiguous. In 2011, Nebraska issued Daryl Parker a full pardon. The state paid $500,000 in compensation, a sum representing 15 years wrongfully imprisoned, decades of criminal record, and a life altered by a confession that had been extracted by the very man whose name the technique carried. The case turned, in the end, not on new forensic science, but on a dead man's admission. Wesley Peary had lived out his years after Nancy Parker's murder, without ever being charged. Before he died, he told his attorney what he had done. Attorney-client privilege held that confession inside the legal system, rather than surfacing it in any public proceeding. It remained there, classified, inaccessible, while Daryl Parker lived with a conviction on his record, a man who could not prove what had happened and could not find the evidence that had always existed. The prosecutor who finally found it in the archive and acted on it did so decades after anyone still living had been directly harmed by the suppression. Parker was in his late 70s when Nebraska cleared him. Parker died in 2023 at the age of 91, having lived quietly in Illinois after his release. He was 24 when convicted and 39 when released, 55 years before Nebraska formally cleared his name. The reid technique became the dominant interrogation model in American law enforcement and remained so through successive generations of officers. Its inventor's first confirmed false confession casualty was documented, prosecuted, and resolved without anyone formally connecting it to Reid's legacy for over 5 decades. John E. Reid died in 1982. Daryl Parker was pardoned 29 years after him. Case number 3. Richard Lapointe. Richard Lapointe suffered from Dandy Walker syndrome, a congenital brain malformation that affected his cognition, his coordination, and his capacity to perform basic physical tasks. He could not easily tie his own shoes. In 1989, Manchester, Connecticut police accused him of breaking into an elderly woman's apartment, overpowering her, raping her, stabbing her, strangling her, and setting the apartment on fire. They interrogated him for 9.5 hours. They told him a polygraph machine had proven his guilt, and Lapointe, unable to reconcile the machine's apparent certainty with his own blank memory, concluded that if the device said so, it must be true. He was arrested on July 4th, 1989, for a crime committed in 1987, and would not be free again for 26 years. Lapointe was born in 1945 in Massachusetts. By the time of the crime, he was 41 years old and working as a dishwasher in Manchester, Connecticut. His Dandy Walker syndrome had shaped every aspect of his daily life. His cognition was impaired, his physical movements were visibly compromised, and his capacity for independent reasoning under sustained pressure was severely limited. He had no criminal record. He was known by those around him as gentle and compliant, a man who accepted what he was told without resistance, who deferred to authority as a baseline orientation toward the world. He was married to Karen, whose grandmother was Bernice Martin, the woman who was killed on March 8, 1987. That family connection had brought Lapointe to Martin's apartment building on prior visits. It would bring police to his door. Bernice Martin was 78 years old and lived alone in her Manchester apartment. Lapointe's presence in her building was documented and known. He had visited as a family member. She was a respected woman in her community, her age and her solitude making her vulnerable in the particular way that elderly women living alone are always vulnerable. On the night of March 8th, 1987, someone broke in, raped her, stabbed her, strangled her, and set her apartment on fire. Firefighters found her body when they arrived to extinguish the blaze. The investigation proceeded for 2 years without producing an arrest. Then detectives turned to Lapointe. What followed was a 9.5-hour interrogation of a man whose medical records documented cognitive impairment and physical limitations sufficient to raise serious questions about whether he could have executed the crime. Detectives told Lapointe his DNA had been recovered from the scene, a false claim stated with the authority and precision of an established fact. They told him the polygraph examination had confirmed his guilt, also false. Lapointe had no framework within which to challenge either claim. He had been conditioned, through both his disability and his temperament, to accept authoritative statements rather than contest them. Faced with the assurance that science had determined his guilt, he reached the only conclusion available to him. Perhaps he had done it during an episode he could not remember. He was not lying to the detectives. He was accepting their lie as fact. The 2-year interval between the crime and Lapointe's interrogation reflected the investigation's earlier failure to produce a suspect from the physical evidence. The fire had consumed much of the apartment, limiting what forensic work could establish. With the case stalled, detectives reviewed the victim's connections and arrived at Lapointe through the family relationship. His wife was Bernice Martin's granddaughter, and he had been inside that apartment building. That documented prior presence was the investigative thread they followed. It led to a 9.5-hour session with a man who, as a matter of documented medical record, could not have committed the crime they accused him of. He was arrested on July 4th, 1989, and charged with capital felony murder, arson, and sexual assault. His defense attempted to suppress the confession, arguing that Lapointe's documented cognitive disability made him incapable of knowingly and voluntarily waiving his rights. The argument did not prevail. Trial was held in 1992 in Hartford County. Prosecutors argued that LaPointe had concealed a violent nature beneath a gentle exterior, that the disability was a mask. The defense pointed to his physical and mental limitations, to the complete absence of physical evidence tying him to the crime, and to the documented medical record of a man who demonstrably lacked the physical capacity to subdue a victim with the force the crime required. The jury deliberated for 6 days before convicting him on all counts. He was sentenced to life in prison without the possibility of parole. The Innocence Project spent years building the case for review. What ultimately freed him was not DNA evidence, but prosecutorial concealment, documentation the state had possessed throughout the entire case, establishing the burn time of the apartment fire. That evidence proved the fire had been set at a specific time, a time at which LaPointe was verifiably at home, watching television with his wife, a fact that constituted an alibi the prosecution had held and suppressed. In 2015, the Connecticut Supreme Court overturned his conviction on those grounds. The state declined to retry him. The true killer of Bernice Martin has never been identified. Richard LaPointe was released in 2015, 26 years after his arrest. He was 41 when taken into custody and 70 when freed. He died 5 years later, in 2020, from COVID-19 complications in a nursing home at age 74. Connecticut, in the years following the exposure of what had been done to him, enacted mandatory recording requirements for police interrogations, a reform whose absence from the 1989 session meant there was no record of precisely what had been said to a cognitively impaired man in a room where lies were delivered as scientific facts. He died without learning who killed Bernice Martin. That question remains open, as it has been since the night the fire was set. Case number 4, Marty Tankleff. In the interrogation room at the Suffolk County Police Department on September 7th, 1988, Detective James McCready picked up the telephone and staged a conversation. He spoke to no one on the other end, but in doing so, told 17-year-old Marty Tankleff that his father, who lay critically injured in a hospital following the attack, had just regained consciousness, named Marty as his attacker, and lost consciousness again. Seymour Tankleff never regained consciousness. He died weeks later without speaking another word. McCready had fabricated the call from beginning to end. The nurse, the revival, the accusation, every word of it. Marty Tankleff, who had found his parents beaten in their home hours earlier and had called 911, heard the lie, went pale, and said he must have blacked out and not remembered what he had done. Marty was 17 years old that morning. He was the adopted son of wealthy Long Island entrepreneurs, attending a prestigious school, living in a mansion in Belterre, New York. He had no criminal record, no background of violence, nothing in his history that explained why a detective would walk into a room already convinced of his guilt. He was, in the language of court documents and later journalism, a normal, privileged teenager. What he was not, at 17, sitting across a detective who had just fabricated a dying man's last words, was capable of recognizing that the authority figure opposite him was deliberately constructing a lie to produce a specific result. The fabricated phone call accomplished what months of ordinary interrogation might not have. It collapsed his resistance in a single moment. Seymour Tankleff was 62, a wealthy businessman who owned racehorses and ran successful enterprises on Long Island. Arlene Tankleff was 54, his wife. Both were well regarded in their community and financially prominent. Seymour had a significant and contentious financial dispute with his business partner, Gerard Steuerman, who owed him large sums he had not paid. That dispute, and the man at its center, would take 17 years to surface in a courtroom. Steuermann, it would eventually emerge, had arranged the attacks. He had the motive, the means, and the desperation. He was not the teenager who had called 911. On the morning of September 7th, 1988, Marty had woken to find his mother beaten to death and his father bludgeoned and stabbed, but still breathing. He called 911 immediately. Detective McCready arrived, walked through the scene, and within hours had settled on the teenage boy who had made the call. No physical evidence linked Marty to the attacks. There was no forensic connection between the crime scene and the boy standing in front of him. What McCready had was the fabricated phone call, the suggestion that a polygraph examination would confirm what the detective already claimed to know, and a sustained implication that Marty had committed a blackout killing of his own parents. Marty's response, tentative, conditional, immediately retracted, was never recorded on tape. McCready's notes described it as a confession. Marty was charged as an adult with 2 counts of second-degree murder and went to trial in Suffolk County in 1990. The prosecution's entire case rested on the unrecorded, immediately retracted statement. The defense pointed to Gerard Steuermann, who had, in the period between the murders and the trial, staged his own death and fled to California, as the man whose financial desperation provided both the motive and the explanation for what had happened in that house. Marty testified in his own defense, maintaining his innocence throughout. The jury convicted him on both counts. Judge Alfred Tisch sentenced him to 50 years to life in prison, 2 consecutive terms of 25 years. Marty was 19 at sentencing. Gerard Steuermann's behavior in the period following the attacks was by any measure that of a man with something to conceal. He liquidated assets, staged his own death, and relocated to California under an assumed identity. Actions that the defense raised at trial and that the jury either did not weigh heavily or did not find sufficient to override the confession. The flight, the fake death, the changed identity. None of it, in the context of a 1990 trial relying on a single retracted and unrecorded statement, was enough to overcome the prosecution's narrative. It would take 17 more years, and the eventual cooperation of individuals with direct knowledge of what Steuermann had arranged to produce the evidentiary record that freed Marty Tankleff. For 17 years, he pursued every available avenue from inside a prison cell, filing appeals, building the evidentiary record, corresponding with investigators who were willing to look again at what Steuermann's associates were saying. New information eventually surfaced through those channels. Accounts from individuals connected to Steuermann's circle describing the arrangement and execution of the attack with enough specificity to matter. The appellate court vacated Tankleff's conviction in 2007. The charges were dismissed entirely in 2008. He had entered prison at 17 and emerged in his mid-30s. Marty Tankleff enrolled in law school after his release, passed the bar, and now practices as an attorney representing wrongly convicted clients. New York State, in the years following the prosecutorial misconduct exposed in his case, significantly overhauled its evidence discovery laws. The blindfold law, which had permitted prosecutors to withhold exculpatory materials from defense attorneys until the moment of trial itself, depriving defendants of the ability to investigate and rebut evidence before it was presented. The reform came too late for Marty, but the fabricated phone call that broke him, the one that lasted less than a minute and was invented word for word, is now part of the legal record that helped change what prosecutors in New York are permitted to do. Case number 5, Peter Riley. After Connecticut State Police told 18-year-old Peter Riley that he had failed the polygraph examination, failed it conclusively, beyond any doubt. And after they had spent hours convincing him that he must have killed his mother in a blind rage he could no longer consciously reach, Riley turned to his interrogators and made a request. He asked them to help him remember how he had done it. He was not confessing. He had been told, with the full weight of official authority and a machine's apparent science, that he had committed a murder he had no memory of, and he was asking for help to recover that memory. His mother had been dead for hours. The actual killer was never identified. Peter Riley was born in 1956 and raised in Canaan, Connecticut, by his mother, Barbara, a single woman in a rural community. He was 18 on September 28, 1973. A high school student, quiet and polite, known to his neighbors as responsible and church-involved. He had no criminal record, no documented capacity for violence, no history of instability. He had spent that specific evening at a youth group meeting at his local church and returned home to find his mother's body. He called the police and remained at the scene. What followed took place over hours in a state police barracks, in a room where troopers had a polygraph machine, and a 17-year-old, by a year, who had no reason to distrust the people he had been raised to defer to. Barbara Riley was 51 years old and had lived with Peter in their isolated rural home outside Canaan. She was unmarried, a woman of strong opinions who had friction with some of her neighbors. The kind of detail that, in a murder investigation, becomes a list of alternative suspects. On the night of September 28, 1973, she was beaten and slashed to death in that house. The investigation would ultimately fail to charge anyone else. The state police, presented with a grieving and cooperative 18-year-old at the scene, developed a theory around him and worked backward from it. Troopers administered the polygraph examination to Riley within hours of his call. They told him the result was categorical, that he had failed it miserably, completely. Over the hours that followed, they built a psychological structure around that false foundation. His inability to remember killing his mother was a product of traumatic suppression, they explained, a protective mechanism his mind had engaged to shield him from the horror of what he had done in a state of dissociated rage. Riley was young, alone, in shock, and had been conditioned to treat people in authority as credible sources. The structure they built was false from the first claim. He could not see that from inside it. He eventually signed a confession. Playwright Arthur Miller, who lived in the area and took a strong interest in the case, helped fund Riley's legal defense and became one of his most prominent advocates as the case attracted national attention. The public dimension of the case grew substantially after Arthur Miller took an interest in it. Miller's involvement, attending court proceedings, writing about the case publicly, helping fund the legal defense, brought national attention to what had happened in that Connecticut barracks and to the broader question of what an interrogator was permitted to do to a teenager who had just found his mother's body and called the police. The case became, in the mid-1970s, a public argument about interrogation techniques, about the reliability of polygraph-produced confessions, and about the obligation of prosecutors to disclose evidence that pointed away from the person they had charged. Riley was arrested in October 1973 and charged with manslaughter, a charge that was subsequently upgraded. Trial was held in 1974 in Litchfield County, highly publicized due to both the defendant's youth and the extraordinary circumstances of a teenager tried for his own mother's murder. The prosecution possessed the confession and little else. The jury convicted Riley of manslaughter. He was sentenced to 6 to 16 years, but was released on bond pending appeal, a consequence of the volume of public pressure the case had generated. The involvement of Arthur Miller and other public figures, having transformed it from a local matter into a national question about what police were permitted to do to an 18-year-old in a barracks interrogation room. The resolution came in 1976 when it emerged that the prosecutor had withheld exculpatory evidence, telephone records establishing that Peter Riley had been at a location miles from the house, making calls, at the precise time Barbara Riley was being killed. A judge dismissed the charges entirely on the basis of that concealment. The confession that had convicted him was the product of a machine's fabricated result and a sustained narrative about his own psychology that had been delivered to him as fact. He had believed both. The hidden evidence was there the whole time. Peter Riley is 68 years old. He has worked in the automotive industry for decades and speaks occasionally, when asked, about what police interrogation can produce when applied to a person who is young, frightened, and has been taught to trust authority. The case inspired a book and a television film, both titled A Death in Canaan, and became one of the earliest nationally recognized examples of the harm an interrogator can cause, using a polygraph as a psychological weapon rather than an investigative tool. Barbara Riley's killer was never charged. More than 50 years after her death, who killed her remains officially unresolved. Her son asked police to help him remember doing it. He nearly spent a decade in prison because of what they had convinced him was true. Case number 6, Gary Gauger. Gary Gauger spent 3.5 years on death row in Pontiac, Illinois, sentenced to die by lethal injection for murdering his parents on the farm where he had lived and worked alongside them for most of his adult life. The evidence against him was a hypothetical. During a 21-hour interrogation conducted without sleep, Gauger had told detectives that if he had somehow blacked out, he supposed he might have done something he could not remember. Police recorded that conditional, speculative statement as a murder confession. There was no physical evidence connecting him to the deaths. There were no witnesses. There was a man thinking out loud through grief and exhaustion, and a detective with a notepad who wrote down what he heard as though it were an admission. Gauger was born in 1952 in Illinois and had grown up on his family's organic farm in Richmond. By 1993, he was 41, college educated, and had spent his adult years farming alongside his parents, tending the land, running the rug business, maintaining the operation that supported the family. He was single, had a history of struggles with alcohol that was documented but not criminal, and was known by those who knew him as peaceful and self-contained. He had never been charged with a violent offense. He had no financial disputes with his parents, no inheritance conflicts, no documented animosity. He had no reason to harm the two people whose farm was also his livelihood, his home, and the structure around which his entire daily life was organized. Morris Gauger was 74 years old and had built the farm alongside his wife Ruth, who was 70. They were long-established figures in the Richmond farming community. Industrious, respected, the kind of couple whose names meant something in a small agricultural town, because they had been there for decades. On the morning of April 9th, 1993, Gary discovered his father's body in the motorcycle repair shop on the property and called 911. Ruth was found shortly after. Both had been bludgeoned, and both had had their throats slashed. Two members of the Outlaws Motorcycle Club had come to the farm the previous day intending to rob the cash safe. Morris and Ruth Gauger had died for what was in it. Gary had been elsewhere on the property during the attack and knew nothing about what had happened. What he knew when police arrived was that both of his parents were dead. Detectives interrogated him for 21 consecutive hours without allowing him to sleep. They told him the polygraph examination had confirmed what they already suspected. They told him they had found bloody clothing in his room, a false statement delivered with the confidence of fact. Gauger, operating on no sleep and acute grief, did what exhausted people sometimes do when official authority contradicts their own certainty. He tried to construct an explanation for something he could not explain. He told detectives that if he had killed his parents, if he had somehow lost consciousness and done something he could not recall, he supposed he would have done it with a knife, in the shop, in the early morning hours. Police wrote this down as a detailed account of premeditated murder. The death penalty was sought from the outset, McHenry County prosecutors argued that Gary Godger's hypothetical statement, the conditional speculative account of what he might have done if he had blacked out, was the clearest possible indication of a man who knew exactly what he had done and was performing ignorance. The defense's counterargument was simple. There was no physical evidence of any kind, no blood on Gager's clothing, no forensic trace linking him to the crime scene in the shop, no witness, no corroboration. The prosecution's entire case was a thought experiment extracted from a man who had not slept in over 24 hours and had just discovered both of his parents were dead. He was arrested in April 1993 and charged with first-degree murder on both counts. The state sought the death penalty. Trial was held in 1994 in McHenry County. The prosecution presented the hypothetical as a cold, deliberate admission. The defense pointed to the complete absence of any physical evidence and to the obvious problems of a statement extracted from a man who had been awake for more than 24 consecutive hours and had just lost both of his parents in the same morning. The jury convicted Gager of both murders. The judge imposed the death sentence, citing the prosecution's characterization of the crime. Godger had been on death row for 3.5 years when an appellate court overturned his conviction in 1996, ruling that his initial arrest had lacked probable cause. The convictions were vacated on procedural grounds, not because anyone had yet proven who had actually killed Morris and Ruth. That proof emerged from federal law enforcement. The Outlaws Motorcycle Club had been placed under extended surveillance as part of a broader organized crime investigation, and wiretaps eventually captured 2 members discussing the Gager farm murders with enough detail and specificity to remove any remaining question. Gary Godger received a full pardon from the governor of Illinois in 2002. He returned to the family farm, married, and resumed the organic farming operation he had spent his adult life building. The county paid him a civil settlement. His case was included in the off-Broadway production, The Exonerated. More consequentially, the Gager case, alongside a cluster of other death row exonerations in Illinois during the same period, contributed materially to Governor George Ryan's decision in 2000 to impose a moratorium on capital punishment in the state. Illinois abolished the death penalty entirely in 2011. A hypothetical spoken aloud in exhaustion and grief, recorded as a confession, had produced a death sentence, 3.5 years on death row, and eventually contributed to the dismantling of an entire state's capital punishment system. Case number 7, Christopher Ochoa. During the interrogation of Christopher Ochoa, a detective reached across and touched his arm, specifically the vein in the crook of his elbow, and told him that was where the state of Texas would insert the needle when it executed him. Ochoa was 22 years old, had never been in serious trouble in his life, and had no connection to the crime under investigation beyond the fact that he had once worked at a different franchise of the same restaurant chain. Several months later, he pleaded guilty to a murder he did not commit, named his innocent roommate as an accomplice, and accepted a life sentence to avoid the procedure the detective had just described on his arm. Ochoa grew up in Texas and was working at a Pizza Hut in Austin when police first brought him in for questioning. He was 22, a high school graduate with no criminal history and no background of violence, a regular young man who had done nothing to attract police attention except exist near a workplace connected to a crime. He and his roommate, Richard Danziger, had previously worked at a different Austin Pizza Hut location. That prior employment was the thread investigators followed. It was not a lead in any meaningful sense. Working at a different franchise of the same chain is not a connection to a murder that occurred at another location. But it was treated as one. It led them to 2 men who had not been present at the crime and had nothing to do with it. Nancy DePriest was 20 years old and managed the Austin Pizza Hut on Runberg Lane. She was married and well regarded by the people who worked for her, a capable manager described by her staff as fair and professional. On the morning of October 24th, 1988, she arrived early to open the restaurant and was alone when Akam Joseph Marino entered. Marino raped her and shot her in the head. He was a serial criminal with an established record of sexual violence and robbery who had operated in Texas for years. His DNA was left at the scene. Ochoa's was not. Neither was Danziger's. Neither man had been in the building. The plea bargain Ochoa eventually accepted was a product of the interrogation's logic as much as its threats. Having been told, repeatedly, and with apparent scientific authority, that the polygraph had confirmed his guilt, and having been shown physically what awaited him if he refused to cooperate, Ochoa understood his situation not as an innocent man being wrongly accused, but as a man whose guilt had already been established and who was now choosing between death and life. That psychological reframing from innocent person to convicted person negotiating a sentence is what the polygraph and the death chamber threat combined to produce. He was not lying when he pleaded guilty. He had been persuaded that he was guilty. Employees found DePriest's body when they arrived for work. Police identified Ochoa and Danziger as persons of interest based solely on their prior employment at a different franchise. What followed for Ochoa was an interrogation process that included polygraph examinations presented as scientific confirmation of his guilt and explicit physical threats about Texas's death chamber. The detective's finger on the vein in his arm, the specific indication of where the lethal injection would enter his body. The message was not subtle. Cooperate, meaning plead guilty, or be executed. Ochoa, at 22, had no reason to believe the state would execute an innocent man. He made the calculation that the threat was real. He would confess, accept life imprisonment, and survive. To secure the lesser sentence, Ochoa also agreed to testify against Richard Danziger at a separate trial. He stood in a courtroom and provided detailed testimony about his innocent roommate's participation in a murder that neither of them had committed. Danziger was convicted on the strength of that testimony and sentenced to life. While serving that sentence, Danziger was severely beaten by other inmates and suffered permanent brain damage, cognitive impairment from which he would not recover. Ochoa, in a cell of his own, had put him in the position where that happened. That was also a product of the interrogation and the threat. In 1996, Akam Joseph Marino wrote letters to the Texas governor confessing to the murder of Nancy DePriest. He described a religious conversion as his motivation for coming forward. The letters were received and not acted upon immediately, a delay that kept both Ochoa and Danziger in prison for several more years. In 2001, DNA testing arranged by the Innocence Project applied the biological evidence from the crime scene and produced a definitive result. The evidence excluded both Ochoa and Danziger entirely and matched Marino without ambiguity. Ochoa was exonerated in 2002. Danziger was also released. Marino was convicted of the murder and sentenced to life in prison. Ochoa had served 13 years. Danziger had served the same and had emerged from them permanently brain damaged. Ochoa used a portion of his civil settlement to attend the University of Wisconsin Law School. He passed the bar and works on wrongful conviction cases. He has spoken at length about Richard Danziger, about the testimony he delivered against a man he knew was innocent, and about what that testimony cost Danziger in years lived and in the permanent damage done to his mind. 13 years of Ochoa's own life were gone. Danziger lost the same years, plus the cognitive function he will not recover. Both losses trace directly to a polygraph, a threat, and a finger placed on a vein in an Austin interrogation room. by a detective who knew what the gesture was designed to produce. Case number 8. Frank Sterling. In 1992, Mark Christie sat in a Monroe County courtroom and testified for the prosecution at Frank Sterling's murder trial. Christie answered the questions put to him, provided his testimony, and helped convict Sterling of a crime Christie himself had committed. Sterling was sentenced and transported to prison. Christie went home. 4 years into Sterling's sentence, Christie murdered a 4-year-old child. The polygraph examination that had produced Sterling's false confession, the examination that had, in effect, handed Christie his freedom, had consequences that extended well beyond the walls of Frank Sterling's cell. Sterling was a truck driver from Rochester, New York, born around 1962. He was 26 at the time of Viola Manville's death in November 1988, working steady long-haul routes and living a working-class life without any documented history of violence. Police initially identified Mark Christie as a person of interest in the Manville case, and then, for reasons never fully explained in the subsequent record, set him aside. 3 years later, in 1991, a flimsy tip pointed investigators toward Sterling. There was nothing in his background that explained why he had killed a 74-year-old retired woman on a hiking trail, because he had not. Viola Manville was 74 years old and retired, living alone in Hilton, New York. She had spent years building her retirement around simple routines, one of which was hiking the rural trails near her home, a habit that placed her on those paths at regular and predictable times. On November 29, 1988, she was beaten and shot with a BB gun by Mark Christie, a local teenager with a documented history of violent behavior. A passerby found her body later that day. Christie had been identified as a person of interest early in the investigation, and then, without explanation in the available record, removed from that consideration. Frank Sterling's name appeared sometime later on the basis of a tip, and the investigation turned in his direction instead. When detectives brought Sterling in for questioning in 1991, he had just completed a 2-day trucking route. He was exhausted in the particular heavy way of physical labor without adequate rest. They placed him in front of a polygraph and told him the results established his guilt, that the examination had confirmed what they suspected. They then offered him a framework for his failure to remember. He had suppressed the memory, they explained, blocked it out the way traumatized people sometimes do under extreme psychological pressure, and with the right prompting, it could surface. Over the course of the interrogation, detectives fed Sterling specific details about the crime scene. Sterling, exhausted and increasingly disoriented, absorbed those details and produced them back when prompted. That process was recorded as his account of the killing. He recanted as soon as he had slept. Sterling recanted the confession the morning after it was taken. He woke, understood what had happened in that room, and told detectives he had not killed Viola Manville, and that everything he had said was the product of exhaustion and manufactured pressure. The recantation was documented. It did not change the direction of the investigation or alter the prosecution's decision to proceed. A recantation in the legal framework of 1991 was treated as evidence of a guilty man trying to walk back what he had admitted. Evidence of guilt rather than evidence of coercion. The confession that had been built by feeding Sterling the details of a crime and recording his repetition of those details as his own account was the document that mattered. The recantation was the document that was set aside. The confession's internal problems were plainly visible. Sterling described a weapon that was not the one used in the killing. The physical evidence and the confession contradicted each other on a basic factual point that should have raised questions about the confession's reliability. It was not treated as a defect at trial. The 1992 proceedings in Monroe County proceeded with the confession as the prosecution's central exhibit. Mark Christie appeared in that courtroom as a prosecution witness and testified. Sterling was convicted of second-degree murder and sentenced to 25 years to life in state prison. He served 18 years before the Innocence Project secured DNA testing on clothing recovered from Viola Manville's body. The results were definitive. The DNA excluded Sterling entirely and matched Mark Christie. By then, Christie had already been convicted and imprisoned for murdering a 4-year-old child, a crime he committed during the years Sterling was incarcerated for Manville's murder. Sterling was exonerated in 2010. Monroe County paid him a multi-million-dollar civil settlement. Frank Sterling lost 18 years. The investigation had found the right suspect first. Christie was on the list before Sterling's name ever appeared, and then turned away from him. That pivot, whatever produced it, left Christie free to testify at the trial of the man who had replaced him on the suspect list, and left him free to kill again 4 years later. The DNA testing that exonerated Sterling confirmed what the physical evidence had indicated from the beginning. The confession's internal contradictions were not the uncertain details of a guilty man's memory, but the errors of an innocent man who had not been present at the crime. The child Christie murdered while Sterling served his sentence had no Innocence Project and no DNA evidence to reverse what had happened to her. There was no accounting for that death. It was the direct cost of the interrogation room's false confession, borne entirely by someone who had no connection to anything that had been done to Frank Sterling, and no way to benefit from anything that would eventually be done to correct it.